Hello, my name is Alexander von der Fellen, and welcome to Trusts Unpacked, where we strip away myth and marketing and explain in plain terms how trusts actually work in real families. For the last 20 years, my fiduciary work has focused almost entirely on the architecture of trusts, the skill of trusteeship, and the challenge of long-term family governance, not as a technical exercise, but as a human. In doing so, I have advised hundreds of families, as well as institutions and advisors across the world. Alongside my advisory work, I am a published author. I recently completed a trilogy that reflects both the technical and the human dimensions of both the fiduciary and private banking fields. Before we begin, a brief but important note. This podcast is provided for general information and discussion only. It does not constitute legal, tax, fiduciary, or professional advice, and it should not be relied upon as such. As ever, you should always seek advice from appropriately qualified professionals in your relevant jurisdiction before making decisions or taking action. Now, up to now, much of this series has assumed a single legal and cultural frame, one family, one jurisdiction, one set of assumptions. But for many families today, that is no longer the reality. Assets are global. Family members move. Citizenship, residence, and identity no longer align neatly the way they used to. This session looks at succession planning for international families and the particular role that trusts can play in that environment, not as a silver bullet by any means, but as a coordinating framework. You see, international families face a different order of complexity, not just more rules, but more friction, different legal systems, different cultural expectations, different attitudes to inheritance, control, and obligation. A family may span common law and civil law systems. Some members may come from forced heirship cultures, others from discretionary traditions. Trusts sit comfortably in some places. They are misunderstood or even resisted in others. Ignoring these differences is one of the fastest ways to create succession problems. Long before international trusts existed, some families solved succession across borders without a single document. In my book Stewardship, I look at the fascinated Marwari trading families of India. These extraordinary groups of people operated for generations as dispersed networks. Brothers in Calcutta, cousins in Bombay, uncles in Rangoon, nephews in Hong Kong. Capital moved constantly, but rarely through formal contracts. What held the system together was reputation, obligation, and shared norms enforced socially rather than legally. Succession in that world was not even an event. It was a gradual handover of responsibility. Younger members were embedded early, tested discreetly, and trusted incrementally. When an elder died, there was rarely a scramble, because authority had already been diffused. But that system only worked while the family remained culturally cohesive and jurisdictional risk was low. Once assets became global, regulations hardened, and heirs married outside the community, informal governance began to stray. What had once been flexible now appeared fragile. I've seen modern international families assume that they can replicate this informality across continents, believing goodwill will substitute for structure. The sad fact is, it rarely does. Distance amplifies misunderstanding. Different legal systems impose different outcomes. Silence becomes ambiguity. The lesson is not that informal trust networks are naive. They are simply extraordinarily effective in their context. The lesson is that once a family becomes international, it needs a coordinating framework that performs the same function deliberately. Trusts, at their best, are not replacements for family trust. They are its scaffolding. They translate informal understanding into something that can survive geography, time, and regulatory mismatch. At a technical level, Trusts are not universally recognized. Common law jurisdictions understand them instinctively. Civil law jurisdictions, on the other hand, often do not. Now, that does not make trusts unusable, but it does change how they must be structured and explained. Key issues include the recognition of the trusts, enforcement of trustees' decisions, interaction with forced heirship rules, and tax treatment across borders. A trust that works perfectly in one jurisdiction may create confusion or even challenge in another. International planning requires coordination, not assumption. We live in a mobile world, and mobility changes everything. Children study abroad, adults relocate for work, residency and tax status shift over time. Succession planning based on a static snapshot rarely survives reality for any length of time. Trusts are often used precisely because they introduce stability into a system that has constant moving parts. They allow assets to remain anchored, governance to remain consistent, succession to unfold over time, but only if flexibility has been built in consciously. Rigid structures, you see, struggle in mobile families. In my book, Stewardship, I wrote about the Hong Kong trading families who learned early that permanence is an illusion. Over the past 70 years, these remarkable families have lived through colonial rule, war, Japanese occupation, communist victory on the mainland, mass migration, financial crises, handover to China, and renewed political uncertainty. Assets have moved, people have moved, assumptions have changed repeatedly. The families that have endured and even succeeded in Hong Kong did not try to predict the future. They built structures that could absorb change without forcing premature decisions. Ownership was separated from management. Assets were held through layers that allowed relocation without liquidation. Succession was staged, not triggered by death alone. What mattered was not where the trust sat, but how it behaved under pressure. Could trustees act independently if family members became resident in different countries? Could distributions be adjusted if tax regimes shifted overnight? Could governance survive if political risk made visibility dangerous in one place, but unavoidable in another? I've seen families fail here by anchoring everything to a single jurisdiction because it felt familiar. When that jurisdiction changed or evolved, the entire succession plan fractured. The Hong Kong lesson is simple. International succession planning is not about locking assets into the right country. It's about creating arrangements that can move, adapt, and re-anchor without collapsing. Trusts work best in this context when they are designed as coordinating institutions rather than containers. When they hold not just assets, but decision-making authority that can respond calmly as the world shifts around them, they can succeed. International families are also cultural systems. Attitudes to inheritance vary widely. In some cultures, equality is assumed. In others, hierarchy matters. In others still, family assets are expected to support the collective. Trusts imported without any kind of cultural translation often fail, not legally, mind you, but relationally. A structure that feels fair in one culture may feel deeply unjust in another. So good succession planning requires explicit conversation about values, not just mechanics. Trust can support those values, but they cannot define them. International succession is rarely about the next generation alone. It's about optionality, where future generations might live, which jurisdictions might become relevant, which values should persist, and which should be allowed to adapt. Trusts are often chosen because they allow decisions to be deferred, not avoided, deferred. They allow trustees to respond to circumstances that the settlor simply cannot predict. That is their real strength in an international context. But this only works if trustees are capable, independent, and supported. One of the least discussed issues in international succession planning is liquidity timing. Assets often sit in illiquid forms, private companies, real estate portfolios, art collections, infrastructure. Yet tax systems frequently demand liquidity at fixed points: death, deemed disposal, migration, change of domicile. International families face an added complication. Liquidity may be required in one jurisdiction, whilst assets are located in another. A tax liability may arise in France, whilst the controlling shares sit in Singapore. A probate obligation may crystallize in Brazil, while cash is held in Switzerland. Trusts don't eliminate this problem, but they do allow it to be anticipated. Good succession planning asks one simple operational question. If an unexpected death occurred tomorrow, where would the cash come from? In domestic planning, this question is uncomfortable. In international planning, it is critical. Without pre-positioned liquidity, families are forced into reactive sales, and these sales often occur under time pressure, in public markets, and at more than suboptimal valuations. Trust structures, however, allow for staged distribution policies, insurance ownership planning, cross-border lending capacity, and the deliberate maintenance of liquid reserves. They allow trustees to sequence realizations rather than scramble. Liquidity planning is not glamorous. It's not even philosophical. But in international succession, it's often the thing that determines whether the transition feels orderly or chaotic. And families who ignore it tend to discover its importance at precisely the wrong moment. Another complication unique to international families is information asymmetry. Different jurisdictions collect, disclose, and interpret information differently. Corporate registries vary in transparency. Tax reporting obligations differ in timing and scope. Banking disclosure regimes are inconsistent. A family may assume that because information is confidential in one jurisdiction, it remains confidential globally, and that assumption is frequently wrong. Trustees operating internationally must understand that regulatory transparency is uneven. Automatic exchange of information regimes, beneficial ownership registers, and compliance frameworks create a patchwork of exposure. Succession planning must therefore consider not only ownership, but visibility. In other words, who will know what and when. This matters particularly in politically sensitive environments. A family with members resident in countries with unstable legal systems may be exposed to risks simply through public association with wealth. Trust structures can separate legal ownership from personal profile. They can compartmentalize information across entities. They can centralize reporting to reduce error. But these benefits only arise when transparency mapping is undertaken deliberately. International planning is not just about tax coordination. It's about managing who can see the structure and how that visibility evolves over time. Now, many international families derive their wealth from operating businesses. Succession planning for passive wealth differs fundamentally from succession planning for operating control. In cross-border families, the tension is even sharper. One child may reside physically near the business. Another may live thousands of miles away. One may work inside the company every day. Another may pursue a different path altogether. Trusts are often used to hold shares in the family business, but holding shares is not the same as governing the enterprise. International succession planning must therefore address three distinct layers: ownership, control, and management. These layers do not need to align in the same individuals. In fact, in international families, they often should not. Trusts can stabilize ownership whilst allowing professional management to operate across jurisdictions. They can prevent fragmentation of voting power. They can introduce independent directors. They can embed shareholder agreements that survive generational change. But the trust alone is insufficient. There must be clarity about how trustees exercise voting rights. Under what circumstances would the trust sell? What happens if family members disagree about strategic direction? International dispersion increases the risk that geographically disengaged beneficiaries feel excluded. Distance breeds suspicion. Trustees holding concentrated voting power must therefore operate absolutely transparently within agreed governance frameworks. Where this is handled well, the trust becomes a long-term shareholder stabilizer. Where it is not, it becomes a focal point for frustration. In today's world, international succession planning increasingly involves political assessment. Families with assets across continents are exposed to sanctions regimes, capital controls, regulatory change, and shifts in property rights. Political stability is no longer assumed in today's world. Trusts can distribute political risk across jurisdictions. Assets may be held through layered holding structures. Trustees may be appointed in stable, neutral jurisdictions. Protector roles may be structured to provide emergency replacement powers. But layering must be coherent. Overcomplexity creates its own vulnerability. If trustees cannot act quickly because authority is fragmented across multiple countries, the structure becomes brittle. International succession planning should therefore include scenario testing. What if a jurisdiction imposes capital controls? What if sanctions affect a counterparty? What if a government challenges foreign trust recognition? Trusts provide a mechanism for coordinated response, but that coordination must be rehearsed conceptually before it is required operationally. Families who treat political stability as permanent often discover, to their cost, that, like everything else, it is conditioned. Many international families incorporate philanthropy into their succession strategy. Philanthropic ambition introduces another layer of complexity, however. Regulatory frameworks for charitable entities and charitable actions differ widely. Tax deductibility varies. Governance expectations are inconsistent. Some families establish private foundations in one country whilst operating projects in another. Others use charitable trusts embedded within broader family structures. But international philanthropic succession requires clarity about purpose and execution. Who selects beneficiaries? How are cross-border grants approved? How is compliance monitored? What happens when younger generations redefine impact priorities? Trusts can provide continuity of mission. They can anchor endowments in stable jurisdictions whilst allowing global deployment. But philanthropic governance must evolve across generations without losing coherence. The most successful international philanthropic families articulate principles that transcend geography. They focus on outcomes rather than institutions. They allow trustees discretion to adapt focus as global needs shift. Without that clarity, philanthropy becomes either symbolic or contentious. International succession planning also often frequently suffers from document fragmentation. Wills in multiple countries, shareholder agreements drafted under different legal systems, matrimonial property regimes, tax elections, immigration declarations, trust deeds, side letters. Each document may be technically correct within its jurisdiction, but collectively, they may simply not align. I've seen cases where a will drafted in one country inadvertently contradicted the distribution framework of a trust in another. I've seen shareholder agreements that impose transfer restrictions incompatible with trustee obligations. I've seen matrimonial regimes that altered asset characterization in ways that trustees had simply not anticipated. International succession planning must therefore include periodic documentation reconciliation. Do the documents speak to each other? Do they speak in one voice? Do definitions align? Are powers consistent? Have legislative changes rendered any clauses obsolete since the last reconciliation? Trusts often sit at the center of a documentary web. They must be reviewed, not in isolation, but in coordination with parallel instruments. Coherence is invisible when present, but it's catastrophic when absent. Younger generations in international families are often far more mobile than founders. They study abroad with ease. They establish businesses in emerging markets. They marry across cultures. They relocate for opportunity rather than stability. This mobility introduces what might be called jurisdictional arbitrage. Beneficiaries may move to countries with favorable tax regimes or to countries with unfavorable ones. They may acquire citizenships that alter inheritance exposure. They may become subject to reporting obligations that trustees did not anticipate. So international succession planning must therefore account for beneficiary-driven change. Trusts can moderate this by maintaining asset ownership at a stable jurisdictional level whilst allowing beneficiaries to move freely. Distributions can be tailored to minimize friction. Investment policy can consider beneficiary residence patterns, but trustees must remain alert. A distribution acceptable in one country may trigger unintended consequences in another. International families therefore increasingly require trustees who understand cross-border tax and regulatory interplay, not merely domestic rules. A family's geography may change faster than its documents. Succession planning must anticipate that reality. Disputes in international families are also complicated by forum uncertainty. If a conflict arises, where will it be heard? Which law will apply? Which court will interpret trustee conduct? Trust instruments typically specify governing law and forum, but beneficiaries resident elsewhere may attempt to challenge decisions in local courts. International succession planning must therefore consider defensibility. Is the chosen jurisdiction respected internationally? Are its courts experienced in trust law? Is enforcement predictable? Trusts located in jurisdictions with sophisticated jurisprudence and clear supervisory frameworks tend to provide far greater stability, not because disputes are welcomed, but because clarity deters opportunistic litigation. Some international families also incorporate arbitration clauses into trust-related agreements. Others rely on carefully drafted jurisdiction clauses to minimize forum shopping. The objective is not to anticipate conflict in a pessimistic fashion. It is to ensure that if conflict does arise, it is contained within a predictable legal environment, because predictability reduces escalation. There's also a dimension rarely discussed in technical planning, and that is psychological geography. International families often carry emotional attachments to specific countries. A founder may associate his identity with the country of origin, even if assets have long since migrated. Heirs may feel little connection to that place. Spouses may identify with entirely different cultures. Succession planning that ignores this psychological geography can create resentment. A trust anchored in a jurisdiction chosen purely for efficiency may feel alien to beneficiaries, Conversely, anchoring everything in a sentimental jurisdiction may create technical inefficiency. The art lies in balancing an emotional legitimacy with structural resilience, something that means maintaining symbolic assets in a country of origin whilst relocating operational control elsewhere. Sometimes it means establishing advisory boards that reflect geographic diversity, even if trustees sit in a neutral jurisdiction. Trusts can provide the legal architecture, but families must recognize that succession planning is also about belonging. If heirs feel structurally displaced from the assets that define family history, governance weakens. International succession planning must therefore require attention not only to tax codes and regulatory compatibility, but to identity continuity. International families are increasingly blended families. Second marriages, children from different relationships, step siblings raised in different countries, former spouses resident in other jurisdictions, new partners with independent legal systems behind them. And succession planning in this context is rarely linear. Different countries treat surviving spouses differently. Some recognize community property regimes, others prioritize children. Some grant automatic entitlements, others rely entirely on testamentary freedom. In blended international families, trust structures can often serve a stabilizing function. They can provide income to a surviving spouse whilst preserving capital for children of a prior marriage. They can stage access based on age or circumstance. They can reduce the likelihood that a surviving spouse's remarriage redirects inherited assets away from the founder's bloodline. But the real difficulty is not structural, it's relational. If the structure is perceived as distrustful or punitive, conflict intensifies. If it is transparent, principled, and communicated early, it can prevent misunderstanding. International blended families require particularly careful drafting of definition. Who is a child? Adopted children included. What about children born through assisted reproduction in a different jurisdiction? What if a child changes legal gender identity in a country whose law differs from that of the trust? These aren't theoretical questions. They arise with increasing frequency in our modern world. Trustees drafted without considering evolving family forms risk, at the very least, ambiguity later. International succession planning must therefore anticipate legal recognition differences between jurisdictions in matters of marriage, parentage, and identity. Precision in definition prevents emotional litigation later. Another area I'd like to address, which is rarely addressed explicitly in succession discussions, is digital property. International families increasingly hold assets that exist purely in digital form. Cryptocurrency wallets, online businesses, intellectual property stored in cloud platforms, social media accounts with commercial value, domain names registered across jurisdictions. And digital assets, you see, introduce two complications. First, access. Passwords, encryption keys, and multi-signature authorizations may be held privately by individuals. If access credentials are not documented securely and legally, value can be lost permanently. Second jurisdiction, digital platforms operate under terms of service governed by specific legal systems. Succession rights recognized in one country may not translate automatically into access rights in another. Trust structures can be used to centralize ownership of digital assets, or at least to provide trustees with authority to manage them upon incapacity or death. But trustees must understand the technical mechanics. Succession planning must now include digital inventories, clear instructions about custody, documented authority to engage with platform providers. Without this, international families risk losing intangible assets that may be economically significant or reputationally sensitive. Digital presence also affects legacy. Online archives, recorded interviews, public commentary. These shape how future generations perceive founders. Trustees may find themselves responsible not only for financial assets, but also for a kind of digital heritage. Ignoring this dimension leaves a gap in modern international planning that will only grow with time. Marriage remains one of the most powerful drivers of asset movement across borders. A child raised in a common law country may marry in a civil jurisdiction with strict matrimonial property rules. A prenuptial agreement valid in one country may be challenged in another. Divorce proceedings may take place in a forum chosen strategically for financial advantage. International succession planning must therefore consider matrimonial coordination. Trust assets are often designed to sit outside personal matrimonial property, but courts in some jurisdictions may scrutinize distributions or treat trust interests as financial resources available to a spouse. This doesn't mean that trusts are ineffective. It just means that trustees must be aware of how marital law intersects with trust law across borders. Proactive planning may include encouraging prenuptial or postnuptial agreements aligned with the trust framework, clarifying beneficiary expectations about asset characterization, ensuring that trust distributions do not inadvertently alter the perceived resource base in divorce proceedings. Marriage across jurisdictions is not merely a private decision. It is a structural event. International families that ignore marital coordination often discover its impact only during conflict. Even citizenship is increasingly strategic. Different passports confer different tax exposures, reporting obligations, travel rights, and inheritance implications. Some countries tax citizens regardless of residence. Others impose exit taxes on relinquishment. Some grant citizenship through investment. Others restrict dual nationality. International succession planning must therefore incorporate citizenship strategy into its analysis. A beneficiary who acquires a new nationality may alter the trust's tax profile altogether. A change in citizenship may trigger reporting duties for the trustees. Renunciation may carry tax consequences affecting trust distributions. Trust structures can provide stability across shifting personal circumstances, but trustees must track changes in beneficiaries' citizenship carefully. International families often underestimate how quickly political change can alter the value of a passport. Travel restrictions, sanctions exposure, or regulatory shifts can transform citizenship from privilege to liability. Succession planning should therefore include contingency thinking about nationality, not in a speculative sense, but in a practical one. What if a key family member becomes resident in a high-tax jurisdiction unexpectedly? What if citizenship laws change? What if travel restrictions limit access to core assets? Trusts can provide institutional continuity when personal status fluctuates, but only if trustees are both informed and engaged. Now let's talk about family offices in trusts. Because as international families grow, many establish these family offices. The location of that office is not merely administrative. It signals identity. It affects regulatory oversight. It determines employment law, confidentiality expectations, and proximity to beneficiaries. An international family office operating in one jurisdiction may well serve beneficiaries in many others. Succession planning must therefore integrate the office's governance with the trust's authority. Who appoints the chief executive? How are investment decisions overseen? Does the family office report to trustees, to a family council, or to both? International dispersion can create duplication, separate advisory teams in different countries, conflicting reporting lines, inconsistent risk tolerance. Trusts can act as a constitutional anchor for a family office, clarifying ultimate authority. But that authority must be exercised with sensitivity to local operational realities. The choice of family office geography also affects talent recruitment and regulatory burden. A stable jurisdiction may offer legal certainty but distance from beneficiaries. A jurisdiction close to the family may introduce political or regulatory exposure. Succession planning must consider not only where assets sit, but where decisions are made. Earlier, we addressed governance and values, but in international families, communication requires structure, time zones, language differences, cultural nuance. These factors complicate dialogue. Trustees and family leaders should consider formalized communication mechanisms, annual assemblies rotating between jurisdictions, judicial platforms for reporting and discussion, educational programs introducing younger generations to trust principles, structured introduction for new spouses entering the family. These mechanisms are not merely cosmetic. They create familiarity with the structure before crisis arises. In international contexts, misunderstandings often stem from silence, amplified by distance. A beneficiary living abroad may feel excluded simply because information seems to flow unevenly. Trustees should not rely solely on legal reporting obligations. They should cultivate consistent communication patterns that transcend geography. The aim is not constant consultation. It is merely informed awareness. Families that communicate across borders deliberately tend to experience smoother succession than those that assume alignment due to a shared name. Succession planning rarely addresses an important aspect, and that is trustee succession. Yet, trustees retire. Corporate trustees merge or exit markets. Regulatory frameworks shift. Individual trustees relocate. In international trusts, replacing a trustee is not always straightforward. Change of trustee may trigger tax consequences in some jurisdictions. It might alter governing law. It may require court approval. International succession planning should therefore include trustee succession mapping. Who replaces whom? Under what conditions? Is there a protector with power to appoint? Is there a mechanism for adding trustees with regional expertise? Trustee continuity matters particularly in families dispersed globally. Trustees often serve as the institutional memory of the structure. Abrupt trustee change without preparation can destabilize relationships. Planning for trustee succession alongside family succession ensures that the structure's stewards are not left undefined. What about relationship and reputational exposure in a connected world? International families, you see, operate in a world of instant information, media scrutiny, social media amplification, data leaks, investigative journalism, public registries. Succession events can attract attention, large transfers, court filings, business reorganizations. Trust structures do often provide confidentiality, but confidentiality is not invisibility. International succession planning should include reputational risk assessment. How visible is the family's wealth? Are there jurisdictions where public filings could attract attention? How might a dispute be perceived externally? Trustees may need communication protocols in the event of public scrutiny. Silence is often appropriate, but preparation is prudent. Reputation once damaged affects not only the family, but its operating businesses, its philanthropic endeavors, and the next generation's opportunities. International planning must therefore integrate legal privacy with strategic awareness of public narrative. In international families, there's often the aspect of currency concentration and monetary risk, because international families frequently hold assets denominated in multiple currencies. Succession planning must therefore consider monetary exposure. A trust holding assets primarily in one currency, whilst beneficiaries reside in others, creates distribution risk. Exchange rate volatility may alter perceived fairness. inflationary environments may erode real value differently across jurisdictions. Trustees should consider currency diversification aligned with beneficiary geography. Investment policy statements may incorporate currency risk management explicitly. Monetary risk is not purely financial. It does have relational consequences. If one branch of the family experiences economic instability due to currency collapse, expectations about support will almost certainly shift. Trusts can provide a coordinated response, but only if monetary exposure is understood in advance. Finally, international succession planning must address time. Different cultures exhibit different attitudes towards time horizons. Some prioritize immediate access. Others emphasize deferred benefit. In globally dispersed families, these attitudes may coexist within the same structure. Trusts are inherently long-term instruments, but beneficiaries may operate in environments that reward short-term liquidity or entrepreneurial risk-taking. Succession planning must recognize and reconcile these differences consciously. Should distributions favor reinvestment or consumption? Should younger generations be encouraged to build independent capital before accessing true assets? Should the trust adopt a perpetual mindset or a staged wind-down approach? International dispersion complicates this further. Economic opportunity varies widely across countries. What appears generous in one jurisdiction may appear very modest in another. Trustees must balance patience with pragmatism. Time horizon discipline often distinguishes enduring international wealth from fragmented wealth. Where beneficiaries understand that the trust operates across decades, not quarters, expectations stabilize. Where time horizons are unclear, however, pressure increases. International succession planning is therefore as much about temporal coordination as geographic coordination. So what does this mean in practice? Well, it means that succession planning for international families is not simply estate planning with more passports. It is a different discipline altogether. It asks families to think beyond death, beyond tax, beyond jurisdiction. It asks them to think in systems. When assets, identities, and lives are dispersed across borders, the risk is not merely legal conflict. It is fragmentation, fragmentation of control, fragmentation of communication, fragmentation of intention. Trusts, used properly, are not merely instruments of secrecy or rigidity. They are coordinating frameworks. They provide continuity where geography cannot. They allow decisions to be made in one place whilst families live in many, but they only work when designed deliberately and governed actively. Let me make the lessons from this episode explicit. First lesson: international families are structurally different. Multiple jurisdictions create friction. Planning must begin with recognition of that complexity, not denial of it. Second, compatibility matters. Trusts do not operate in a vacuum. Recognition, enforcement, and tax treatment vary. Coordination across legal systems is therefore essential. Third lesson: mobility is constant. Residence, citizenship, and economic activity will almost certainly shift over time. Structures must absorb movement without forcing liquidation or reactive decision-making. Fourth, liquidity cannot be an afterthought. International tax systems and probate rules often require cash at fixed points. Preparation prevents distressed outcomes. Fifth lesson: ownership, control, and management must be distinguished, particularly in family businesses. Stability of ownership does not require identical involvement. Sixth lesson: political and regulatory environments change. Structures should be capable of responding without paralysis. Seventh, documentation must be coherent across borders. Wills, shareholder agreements, matrimonial regimes, and trustees must speak the same language, even if they're drafted in different countries. Eighth, next generation behavior will reshape the structure. Mobility, marriage, citizenship, and entrepreneurial activity introduce entirely new exposures. Trustees must remain attentive. Ninth, communication is not optional. Distance amplifies misunderstanding. Structured dialogue preserves alignment. 10th lesson, trustee continuity matters. The succession of the stewards of the trust is as important as the succession of beneficiaries. 11. Identity should not be ignored. International planning is technical, but families are emotional systems. Legitimacy matters as much as efficiency. And finally, the 12th lesson, and that is that succession in international families is not a single transfer. It is an ongoing calibration between continuity and change. Trusts do not eliminate uncertainty. They create a stable platform from which uncertainty can be managed calmly. In a world where capital moves instantly and families disperse naturally, that stability is not a luxury. It is a necessity. International wealth does not survive by accident. It survives through coordination, discipline, and institutional memory. Trusts, when designed and governed with care, provide exactly that, and that is succession planning for international families. Unpacked. Join me next time for our penultimate episode, where we will unpack the question of trust in today's changing regulatory world and what advisors need to watch. Until then, I am Alexander von der Fell.